Welcome back to the Licensing Subcommittee decision, Wednesday the 16th of April. In the matter of the Licensing Act 2003, application for a premises licence 11 to 13 Albert Road, Southsea, PO5 2SE. Decision. The subcommittee has considered very carefully the application for a premises licence at the premises known as a convenience store. It has gave due regard to the Licensing Act 2003, the licensing objectives, statutory guidance and the adopted statement of licensing policy. The subcommittee considered the relevant representations, both written and given at the hearing by all parties, human rights legislation and the public sector equality duty has been borne in mind whilst making the decision. The application related to a shop premises, previously a hair salon, and is for the provision of a retail sale of alcohol off sales. The application is an experienced operator and currently manages 3 similarly licensed premises in Portsmouth. The applicant had agreed conditions with the police in relation to CCTV, training of staff, a Challenge 25 policy, refusal logs, the restriction of sales of beers, ciders or lager of 6.5% or over, and the availability of records should be there if any incident of crime and disorder at the premises. The subcommittee noted that there had been representations from 5 residents objecting to the grant of the licence due to concerns about crime, disorder and public nuisance, including antisocial behaviour and drunkenness in the area. It was noted that no representation had been received from any of the responsible authorities and that a lack of representation had to be inferred as no objection being held. The statutory guidance and case law being clear that each responsible authority is usually the main source of advice for their respective field. The subcommittee was referred to paragraph 10.15 of the statutory guidance, which indicates that shops, stores and supermarkets should normally be free to provide sales of alcohol for consumption off the premises at any times that the premises are open unless there are good reasons based on the licensing objectives to restrict the hours. After having heard all of the above evidence, the subcommittee determined to grant the proposed application as applied for. Reasons. Objection from residents focused upon the number of existing licensed premises, a potential increase in nuisance and disorder, including harassment of the public given the proximity of a school and a theatre, an increase in issues due to the number of premises in the locality, drunkenness, criminal damage and theft from stores was raised. The subcommittee heard that the following discussions with the police prior to making the licensing application, the hours for opening and licensable activities were reduced on Fridays and Saturdays to address police concerns about issues in the area after 2300 hours on these days. The subcommittee noted that commercial need for additional premises could not be considered. The subcommittee heard that the applicant is an experienced operator and offered conditions relating to comprehensive CCTV system, training of staff, Challenge 25 policy, refusal logs, access to records, and the prohibition of the sale of higher strength beers and lagers. The subcommittee acknowledged the statutory guidance indicates that shops ought to be generally permitted to sell alcohol during hours the premises are open, unless there is a good reason that the responsible authorities are experts in their respective fields and accordingly attach weight to the fact that the application is in effect endorsed by the way of lack of representation. The subcommittee balanced the interests of the business, noting the steps outlined to address concerns of local residents relating to potential issues and determined that it would be appropriate to grant the licence as applied for. There is a right of appeal for all parties to the Magistrate Court. Formal notification of the decision will be set out in full. Thank you.